of all, let's start from the very basics. The first and foremost question, which definitely needs to be addressed, is why should you moot? Now, all of us can understand and appreciate one point, that we often don't want to do something because we have a fear of the unknown. What is the fear of the unknown? The fear of the unknown is something which precludes your effort into doing something because you don't know the entirety of that activity. So, take for example my own experience. When I was in my first year, I did not moot, and I used to give reasons to myself of for not mooting, that it's too tough, it's too biased. Sometimes I would say that no, it's useless. But deep down inside, if I can tell all of you very candidly, the reason why I did not moot was because I did not know how to read a moot proposition, how to draft a memorial, how to actually answer to the questions of the judges. So these three things seemed very daunting to me in my first year, and that is the exact reason why I did not move. And that, I think, is also one of the prime reasons why a lot of law students fear to take part in this activity. But to all the attendees, I would like to tell you one thing. The minute when I decided to do my first moot, which was in my second year, I just kept on improving on my skills of being a better lawyer. By that, what I simply mean is that as a lawyer, when you graduate out of your 5 year law school, as lawyers in the market, all you need is a skill set of three things. First is that you should be able to research properly on any given legal proposition. This is also something which Professor G.N. Sinha pointed out, that research is something which used to be there at his point in time as well, and it's still relevant. It's probably the most relevant thing for any lawyer in the world, which is legal research. So your legal research skills are definitely tested in any moot court competition, be it an intra-university moot court competition, or be it the world's best moot court competitions such as Philip C. Jessup, William C. Wiss, and all of these. And the second skill set which everybody needs as a lawyer is your drafting skills. What do I mean by drafting skills? That, okay, if you've done research on a particular legal proposition, you should be competent enough to prepare a legal draft which your client can understand, and at the same time which the court is able to understand in terms of the legal jargon, the specifics in law, right? So your drafting needs to be very, very precise, concise, simple yet not so simple that it seems very, very childish to the court, right? So second skill was your drafting skills. Your third skills would be your oral argumentation skills, or as we call it, oral advocacy skills, right? So what do I mean by oral argumentation skills? Any lawyer at some point of time requires that he or she go in front of, let's say, a judge, or let's say a client, or an arbitrator, or any kind of person who's making a judgment, or who's probably evaluating you. You are required to present your arguments in the most succinct manner. So what I'm basically trying to tell you is, mooting is one of the most unique activities which involves the congregation of these three activities, these three skill sets, pardon, which are drafting, research, and oral advocacy. In no other co-curricular activity, it is actually, if you may think about it for a minute, debate competitions, research skills not tested enough, drafting skills not tested enough, MUNs, uh, all skills tested only at a very preliminary level. Research papers, more advanced than debates and MUNs, but at the same time, your oratory skills are most often not judged properly or not tested properly. So if you look at it from an objective angle, you will realize that moot court competitions are very unique, and you don't find moot court competitions for engineers or any kind of other students in other disciplines, because moot court competitions are very, very unique to law students. You may actually find engineers doing a lot of debate competitions, sometimes MUNs also. So, and of course, writing research papers is, doctors write research papers, engineers write research papers. So, mooting is a unique skill which I personally believe that all students must take part in. And when I graduated from National University Odisha, I realized that my mooting skills have actually helped me hone these three skills very, very immensely when I was working with Shardul Amarchand Mangaldas as an associate. So yeah, that's my take on why you should moot. I know a lot of you might still not be convinced as to why, if I should if I should participate in the upcoming next moot or not. But let me put forth a few more points in the course of this entire session, which may be convincing enough to you to take up mooting as an extracurricular activity. The second is how to choose a moot, which is a very commonly asked question. The way to choose a moot is not simply by going on the value of the moot. For example, if you think that, okay, Jessup is a very good moot, probably I should do it. This is a very good moot, I should do it. That, according to us, is not the correct criteria to judge whether you should do a moot or not. The correct criteria to judge this thing is, first of all, you should look at your own skill set. What are you good at? Are you good at a particular subject area? Have you recently studied constitutional law, or are you remotely interested in corporate law? Do you have any kind of background knowledge on, let's say, international law, or does a friend of yours have any kind of experience in international moots? So if you answer these questions in your mind, you might be able to come down to, let's say, the shortlisted 10-15 moots which you can plan to do, right? Let's say your area is constitutional law, so you can probably look up some top 4 or 5 moots of India, let's say BCI moot or KLA moot. These moots you can shortlist and see, okay, these are something which I can focus on. The second criterion is basically to understand what your level of expertise is. As everybody knows, most moot court competitions allow participation of 3 team members. You need to see what are the strengths and weaknesses of the 3 moot team members. Are they participating in a moot for the first time? If yes, then choosing a moot which is at a level of a tier 1 moot. When I say tier 1 moot, it simply means most international moots and a couple of national moots like DM Harish. So these moots, if you look at these moots, then you might want to think about it again. If all of you are first time mooters, especially in your first years, it's and I want to caveat myself by saying that I'm not discouraging you to not pick up a moot which is difficult if you are mooting for the first time. But what I personally think is, if you actually remember your school days, if you remember in maths, how did you used to, let's say, go on to a tough topic like trigonometry? First, you used to start off with algebra, right? First, you used to do the easy questions, then the medium questions, and then the difficult questions. And that is a good trajectory for your learning curve, right? So my suggestion to you would be, if all of you are new first time mooters, probably go for a moot which is new, which is easy, which is known to not be so tough. That will also boost your morale, because if you win it, and I really wish that you win that moot, if you win it, you will definitely have a very good boost in your morale, and you will be encouraged more to do another moot, which is very important. Okay. The next thing is how to choose a moot team. A very, very contested, debated topic, because a lot of times, a lot of us think that choosing a moot team based on friendships is something which is okay. While I think it's convenient, it's comfortable to choose a moot team which comprises your friends. At the same time, I want to warn you that please try to think from an objective angle as to what your personal relationships and what your professional relationships should be in your entire life, right? So you should always try to maintain a balance between the two. And just because someone is your friend and that person thinks that, okay, you guys might gel well together and that's why you should move, that may not be the correct criterion to uh, choose a mood team. The correct criterion to choose a mood team is to look at the working relationship of any two people. Now, a lot of times, I want to go back to my law school days. We were asked to form teams for group projects for our subjects in law school based on the roll numbers which we had. And a lot of times, a lot of groups had a major conflict because two people simply couldn't work together. So that just goes on to show that what is most important is how good your working relationship is. So please, the next time you want to choose a mood team, please make sure that you think about it, what your working relationship with that person is. Okay. Now let's come to the first and foremost most important topic of today's discussion, which is memorial making, something which Rachnendra and I have been closely following since the last 8 years, I believe. Memorial making, as Professor G.N. Sinha pointed out, I'm very happy that he said that mooting is also a science. What is the science? I hope all of you know the difference between art and science. It's the difference between creativity and analytics. What science of memorial making or mooting means is that there is a formula, there is a way. If you follow that way, if you follow that formula, your chances of winning the best memorial award at any given moot court competition, I repeat myself, any given moot court competition in this entire world will be very high. We have personally been working with teams who have won best memorial awards at teams at moots like Jessup Internationals, William Seavis, and you name the moot, we have helped that team win the best memorial. So we can vouch for this fact that there are a couple of tricks which are involved. There are a couple of uh, pardon me if I say this, there are a couple of secrets which, in fact, our college, which is NLU Odisha, was aware about. And that's precisely the reason why during 2011 and 2016, NLU Odisha used to bag most of the best memorial citations of any given moot court competition. In fact, that is how Rachnendra and I also learnt the art, and it's just that we thought that this secret should be known to the remaining interested mooters, because ultimately what we care about is that the whole community of mooters grow together, right? And precisely because of this reason, we came up with our workshops on memorial making, and especially our uh, flagship online certificate course on memorial making, which we will talk about in the later slide. Okay. So for memorial making, there are three aspects. And these three aspects, I will talk about all of these three one by one, but I just need you to have a look at from a cursory angle. Okay. So does anybody here know? Now I want everybody to use the chat window. Does anybody know the exact rule which is applied to draft any kind of legal draft? Is there a particular rule which all lawyers, all law students in the world follow to structure their legal draft? If you don't know the rule, then you can, yeah, yes. If for people who are writing, yes, I would like you to mention that rule if you know about. It's a very well recognized four-letter rule. Exactly, exactly. Shruti Poddar, so and Janvi Pandey. You guys definitely are, you have the secret of drafting inside your head, which is ILAC, or something which is also called IRAC. What is IRAC? What is ILAC? And now I'm again going to share a personal story with you guys. When I entered law school, honestly, my aim was not to become a great lawyer, to have the knowledge and the credence of a lawyer like, let's say, Ram Jethmalani or Fali S. Nariman. But what I always wanted to do was I wanted to do good in law school, right? But when I used to frame my exam answers, when teachers used to ask me ask us in the exam question paper, they used to ask questions like, okay, so and so is the case. Now draft a legal answer to this, like a proper legal draft for this answer. And I always used to be confused. What should I put first? Should I write the names of the cases which I know, or should I write the actual argument itself, what I personally think? Right. So I was very confused, and I always used to think that maybe the law fraternity is not so evolved as I thought, and probably nobody knows what anybody is doing. But then what happened was I came across the golden rule of IRAC, and I found out that not a lot of Indian universities, in fact, I don't think there are any Indian universities at present which have a dedicated subject on IRAC or ILAC. In contrast, in European law schools, in law schools like Oxford, Columbia, in US law schools as well, Cambridge, so all of these universities have a dedicated subject for their bachelors for IRAC or ILAC. And that struck me. That was an eye opener for me, because I thought I'm missing out on a lot of important things, probably because of a location disadvantage, of a geographical disadvantage, probably. But what I thought to myself was, okay, now what is, let bygones be bygones. Let's start from where I am right now. And then I started exploring the rule of IRAC. What is the IRAC rule? As Preetpal Singh has correctly pointed out, IRAC is issue, rule, argument, conclusion. The four parts of writing any exam answer, any research paper draft, any law article, any kind of moot memorial, or any kind of legal draft which you will ever need in your legal career. Right. And this was such an eye opener to me that even till today I ponder over this fact as to why not a lot of people know about it. Precisely the reason why we focus on this rule so much in our online courses, because it's the foundation for any law student to become a better law student in terms of writing exam answers, research papers, and then ultimately becoming a good lawyer. In my personal experience, when I found out the rule of IRAC, my pointer, my CGPA moved so closely to the proper 8.0 CGPA that I cannot stress on this fact enough. Now, a lot about the background. Now, let's come back to what IRAC is. What IRAC is basically, for any legal draft, you always start by explaining what the issue is. Let's say the issue at hand is of theft or murder. Then you, in let's say 1 or 2 sentences, you need to explain what the issue at hand is. If let's say a theft has been committed, and then the issue is whether or not the property which was stolen was a movable property or not. As many of you might know, that for theft, one of the ingredients is that the property should be movable property. So let's say the issue is whether the property was movable property or not. So that forms your first point of IRAC. The second point is your rule. What rule exactly means is, whatever the issue is, you need to now write about the applicable law, the applicable case law, the applicable statutes, or any kind of rule or law which is applicable to the issue. Now for theft, what will be applicable? Of course, the IPC will be applicable, and of course, some some kind of jurisprudence in which you have taken out from, let's say, case laws or from books would be applicable. So while writing the rule, let's say in 3 to 4 sentences or even more, there is actually, I shouldn't prescribe a limit for this section and the next section. But yeah, for rule, whatever you know about the law, you need to write down in the rule part. Then comes the most important part, which is the argument part. What is the argument part? Once you know what the rule is, once you know what the issue is, once you know what the rule is, now you need to apply the rule to the issue and form your own argument, which you have thought in your head. Okay, this property is considered to be movable property because of so and so case law. Therefore, the answer to the issue is that this property is movable, and therefore, my argument would be this. The argument part of any legal draft will most often flow in paragraphs, 2, 3, 4, 5, 10 paragraphs. There is no limit. Especially in research papers, the bulk of your writing would be dedicated to the argument part, because here you are trying to explain the jurisprudence, the critical analysis as to why the issue and the rule are connected, right? So once you have prepared a structure till argument, you simply, then what you need to do is you need to write the conclusion, which is the most easiest part of this rule. Conclusion is nothing, just in 1 or 2 sentences you have to conclude by saying, therefore, since blah 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 has happened, therefore the property is movable property, and therefore the issue at hand is in the favor of my client, or whatever, right? So basically, the purpose of the conclusion is to remind the reader about what you are ultimately trying to say. So after you've blabbered for 2, 3, 5 paragraphs, the reader might not remember what the exact issue at hand was, right? So for this, you need to write what the conclusion is in 1 or 2 lines. The next part of memorial making is your research, which is again something which I used to be thoroughly confused about in my law school as to where should I start it from, what is Manupatra, what is SEC Online, am I allowed to use Indian Qanun or not? So yeah, all of these things also came to my mind, and I'm sure that these thoughts might have crossed your minds as well. Just a second. Yes, sorry. So your research part would basically include the understanding of the concept of primary and secondary sources. What are primary and secondary sources? Primary source is any source which comes from the 3 pillars of your government, which are basically the judiciary, the executive, or the legislature. The legislature drafts your actual law. So any kind of bare act which you see will be actually the the articulation of anything which the legislature has propounded. The executive can be bodies like the police, or or any kind of body which is executing the functions of the government, right? So any kind of order from any district magistrate all of these would be categorized under the executive head. Judiciary, of course, needless to say, any kind of case law which any court gives in any case comes under the head of judiciary. So once you have an understanding of what primary sources are, it's very easy to understand what secondary sources are. Anything which is not primary source is going to be secondary source, right? So my question to you would be, and I want you to answer in a yes or no format in the chat box. Would a book by an eminent author, let's say D.D. Basu, would a commentary by D.D. Basu on constitutional law of India would that be a primary source or a secondary source? I'm very happy that I don't need to explain more. Yes, you guys have understood it perfectly because it does not come out from the three pillars of government. It is not a primary source. Now, this is very basic, right? This is something which most of us know. But do you guys know how to how to start your research? This is something which we are dealing with in a lot of our online courses, and also in one of our online courses specially meant for writing research papers, which is going to come up in a month or so. The basic question is, how do you start a research? Can anybody tell me in the chat box? In fact, I know the last answer by Ria Goyal is secondary, was for the earlier question, but the answer to this question is also secondary. You never start from the primary sources. You always start from a secondary source. Let's say today I get a moot proposition which talks about, yeah. So let's say we get a moot proposition about a topic, let's say lifting of corporate wheel vis-a-vis uh, separate legal identity in corporate law. Now that I know what the issue at hand is, what do I need to do? Do I start by picking up the Companies Act directly? More often than not, that would not be very helpful. What you always start with is a secondary source of law. So let's say your moot is on constitution law, corporate law, whatever law it is on. You first need to start with a secondary source of law, such as a commentary, a book, or any kind of other secondary source, which helps you understand what the issue is. Right. Let me give you a very relatable example. Now, let's say today I tell you guys, look up what, let's say, yeah, let's say I tell you guys, look up what the insolvency procedure for a partnership is, right? Now a lot of you will be confused, okay, what act do I look at? Because some part of Companies Act also covers partnership. The Partnership Act is actually meant for the Partnership Act. So what is the exact, source which I should look at? And precisely here at this point of time, you need to learn the fact that you always need to start from a secondary source. So secondary source could be something like a commentary on Partnership Act, or simply as simple as Google. You simply write on Google, okay, insolvency of partnership. Then the first two links you see, okay, it's like article, that legal research papers. You have a look at them, and then you understand what the issue is. And then in those articles or research papers, you might be able to see case laws and statute provisions. So what you are essentially doing is you are moving from secondary source to primary source, right? So this is something which a lot of students have a problem with, as in they, before they know about this trick, they are always confused as to how to start secondary or primary source research. So this is going to be our suggestion. The next time you have a legal proposition in your hand, always try to start with the secondary source. From the secondary source, come to the primary source, which is going to be through case laws, through statutes, or any kind of other.
Our only purpose of hunting down a primary source to back up our argument is because primary sources are the only sources of legal authorities which are binding in the court of law. So if you want that your argument should be backed up with enough authority for the bench to be persuaded enough to accept your argument, then you need to hunt down the primary authorities on that relevant part of law. Yeah.
Yes. So now that we have touched upon research, let's go to the most underrated part of memorial making. Now, just a few moments ago, I told you that NLUO, my alma mater, had a couple of tricks which we used to, use to win any kind of best memorial. Rachnendra and I have personally sat on 15 or so memos during our law school to help our friends to format their memorials in such a way that their memorials stand out from the crowd. Because all the attendees, please understand that your memorial is something like a product. Oh, sorry. Your case is something like a product. Whatever you argue in front of the bench, your arguments are going to be your product. Let's now completely forget about law moot court competition. Let's take a very simple example. Tomorrow, if I were to tell you that, on your Instagram feeds, if you see two ads, one ad is of, of a cookie company, a cookie making, a biscuit making company, and the ad is very, very attractive. It looks the cookie in the ad looks so delicious that you want to order it. And ultimately, what we often do is we just click on shop now, and sometimes, we just can't control our urges. And then when you scroll down your feed, you see another ad, and the advertisement is very basic. It has nothing. It just simply says, buy a cookie, INR 50, good taste. So what I'm assuming is that not a lot of people will be impressed by the second ad. And trust me, guys, as peculiar it may sound, your case is the cookie and your formatting is your ad. So your advertisement to the judge, to anyone who's checking your memos, should be such that on the first instance, when the person looks at your memo, he or she goes like, oh, okay, this person knows something. This person has done a bit of effort more than other people as well. Right. And in fact, Rachnendra and I regularly check memos of moot court competitions. You name a moot court competition which is happening in India, we might have been associated with the memorial checking of that competition. So we can tell you from first-hand experience. In fact, right after this webinar, Rachnendra has to go and check 30 memorials of a school in Bangalore. So what I'm trying to tell you is the formatting parameter is something which law students pay very, very minimal attention, and this is their biggest mistake. What does formatting mean? When I talk about formatting, what you actually need to know is you need to be a master of a software called Microsoft Word, right? And unfortunately or fortunately, and believe me, I wouldn't even say believe me or not, believe me, Microsoft Word is going to be the most important software next to WhatsApp for any law student or lawyer. All lawyers need Microsoft Word at least 6 to 7 hours on a daily basis. So if you don't master that skill right now, what you will essentially do to yourself is you will reduce your employability. Tomorrow, if, and this is from a personal example, when I was interning with Shardul Amarchand Mangaldas, something which my seniors pointed out often was that your drafts look very neat. Okay, the research is, of course, at par with any other good intern, but the draft looks so neat that at one point, and this is one of the prime reasons why I actually got a pre-placement offer at Amarchand Mangaldas in my 4th year, was because the draft which I had submitted to my senior was directly shown to Shardul Shroff without much correction, and Shardul Shroff sir approved that draft with minimal correction. What that goes on to show is basically that the intern who has drafted this is capable enough to become an associate tomorrow and to draft beautiful memos. So again, formatting is an art which you can learn at this stage at memorial making. Unfortunately, memorial making formatting is something which is very, very time taking in terms of, if I talk about, teaching that art to you in this session, it's simply not possible. This is the precise reason why we have taught in terms of 5-day, 7-day workshops, or through our online certificate course on memorial making. We have taught over 5,000 law students about the art of memorial making. I'm sure some of you we have. Rachnendra, how many students do we have from UPS for the memorial making course, about 50-ish something, right?
Yeah, close to 50.
So basically, there are people amongst you who know about the formatting art. They might not tell you about it because that is something, if if you tell about that to a lot of people as friends, they start asking you for help, which is what happened with Rachinendra and I. We were asked to help on memos on a repeated basis, and this is why we actually thought, okay, rather than helping people directly, let's teach people how to do it, right? So unfortunately, I wouldn't be able to tell you a lot about formatting.
But
Uh,
Anand, I think guys, you should know for now. There's one trick as Anand was pointing out earlier. There are tricks of making a memo. One trick which is actually very beneficial and not many students know when they start mooting or even after their first and second moot, how to improve upon the drafting and formatting of their memorials in order to make them fit for the position of a best memorial. This is one trick which you can follow and it is very easy to follow. What it does is it brings coherence to your memo and it makes you it tells you what to do, how to go about making your memo. That is, you choose a moot and you pick out the best memorials of that moot from the past year. So you get a clue what method of drafting was it which was appreciated in the past year in this moot, appreciated enough to win the best memorial. Or sometimes students ask it very often that should I go for heavy formatting or should I just go for formatting with minimal borders, just appropriate line spacing, font size and font style. How much border should I use? Should it be more bold, italic? So this is a call which you make after looking at the best memorials from the past year. You get a clue what is being appreciated by that particular bench, by that particular organizing committee which is organizing that move. Are they appreciating heavily formatted memo, like huge number of citations, like 200 citations, one back the best memorial? So you should go for a memo in which is loaded with citations. Or if you get a clue that the last year's memo only had 80 citations and it still won the best memorial prize, then you should have an idea about that the organizers are not focusing much on the heavy formatting or heavily loaded citations part. Rather, they are focusing on the quality of your research and argument. So this is how you can get a very fair idea about what the examiner is looking at. Whenever you're preparing for an exam, you should have an idea about what to expect from someone who's marking you. So this is where you can gauge upon the parameters which will help you. Your hard work will be more focused if you have a guidance from the past year's best memorial. So this is one trick which you can use to improve upon the drafting and the formatting part.
and believe you me, guys, this is just one trick. Okay, there are so many tricks which are involved. If you want to know more about it, we will obviously be at the end of the session. We will be unfurling some exclusive discounts on our online certificate course on memorial making, through which you can actually learn and win best memorial. Anyway, moving forward, let's come to the oral round or oral advocacy part. By the way, for everyone's clarity, when I say oral round preparation, oral argumentation, oral advocacy, all of these mean the same thing. So don't be confused as to what these, confusing words mean. Okay, now what I will first tell you is the of a few pointers which I want to mention based on the moods which I have judged recently also. Um, One very common mistake which speakers at moot court competition do is what they think is that when their memorial rounds are over, what they need to do is they simply need to prepare the narration of their memorial, which is very very wrong. That is not how you are supposed to uh, you know um, execute your oral round. Just a second, guys. Yes, sorry. So yeah, my first advice to you would be never ever, let me repeat, never ever read from your memorial. That should not be your focus. As a first time mooter, I can understand your urge to read from the memorial because that seems easy, that seems comfortable, but it actually is very it makes your marking very, very low, because I'll tell you why. As judges, how we filter out bad participants from good participants is we focus on these things, as we focus on experienced versus first time mooters. And the best way to do that is, if somebody is reading out from their memorial, that person is a very, very new mooter. So even if you are a new mooter, I would ask you to focus on this trick, which is not to read from your memorial. But if I'm asked to not read from my memorial, can anybody tell me, is there any other kind of document which I need to prepare, which I can memorize, like a script or something? Can anybody tell me if anybody knows about that term which I'm referring to? In fact, one half of the term was mentioned by me in the last sentence. Sticky notes. Good idea. I have actually done that in a lot of moods. Structuring the speech, yes, Janvi. But how, like, is there any document through which you should prepare the speech? Amisha Gupta, short notes. You guys are very close, very close. Satyam, compendium is something different, because compendium is a collection of the documents of the actual printouts or the PDFs of the actual, the statute or the case law. So that may not help you much in what you will be saying out loud as your speech. Okay, so for everyone, mind mapping, prescribing the proposition itself, no. So you guys are very close. Summary of arguments, you guys are very close. But if I were to narrate the summary of arguments, would that look good? Would that look good on for the judge? No, correct. That is the correct answer. So guys, now what you need to understand, and I'm telling you this information firsthand from winners of moot court competitions, of international rounds, of Philip C. Jessup moot court competition, of dear friend Shreya, who was in the winning team of international rounds of Jessup, who is also one of the creators of the course on oral argumentation, which we have on our website. What every professional experienced mooter uses is something which is called a transcript. I've written it down for everybody's convenience. What is a transcript? Transcript, एक second. Yeah. What is a transcript? A transcript is a speech which you have prepared in advance, which you memorize, which has short notes, which has sticky notes. So it is a congregation, it's a compilation of all the things which you guys were saying, but there's a specific format of a transcript. Can anybody tell me what generally is the first sentence which any speaker says out loud in a moot court competition? The first sentence. And most of you know about this. Okay. So the first sentence, and now you will go like, okay, this is definitely the first. Why did I not write this? Addressing the bench. Amisha Gupta, bang on. So addressing the bench is the first thing which you take up, and is also the first part of your transcript, right? So your transcript is structured in a manner in the way in which your oral speech will go. So first of all, you mention in the transcript, if it may please the bench, the council would like to refer to the bench as your lordship, your ladyship, your excellencies, your honor, or whatever you might want to address. By the way, you don't say your excellency for certain moods. You don't say your honor for certain moods. This is something which we might not touch in today's session, but it's something which you definitely need to know what is used there. In fact, there's a recent judgment, not a judgment, actually a comment by a judge of the Supreme Court in the last 1 or 2 months. He told when to use what. He's the CJI. He told what is to be used when. Okay. So opening statement is always addressing the bench, right? But as a first-time mooter, I did not know what a ladyship is, what your lordship is. And in fact, I wasn't even sure if this should be my first sentence. But then through the during the course of the last 8 years, what we have done is we have formed formats of transcripts which are structured in a manner which go like, first you address the bench, second you come to the facts, third you go to the jurisdiction, fourth you go to the arguments, fifth you conclude by prayer. So these are the five main parts of the transcript. But of course, it's not so simple. There are specifics inside the transcript, which, if anybody is interested, we will be telling you about our course on oral argumentation. You guys can have a look at it. Mooters who've won international JESUP, experienced mooters, like if anybody has heard Shaunak Rajguru, and people who are now studying in Cambridge, Harvard, you name the college, we have people from that college who have created that course on oral argumentation. So these people, what they have done is they have, from their own experience, they have submitted some transcripts, and this is just one module, by the way, transcripts wala. They have submitted formats of transcripts which the students of that course can use in order to prepare for their next moot. So these kind of documents will be very helpful for any moot court competition. Right. So first of all, what I wanted to clarify was you do not read from the memory. The second thing is, and I'd like to tell you guys about a personal story. I think a week ago, one student from a college in Bangalore, basically we're helping them conduct the intra-university moot court competitions there. She asked me, sir, what is the appropriate time to start your oral round practice? So I told her that, it totally depends on your level of expertise, but the minimum time I would give, if allowed, between your memorial submission and your oral rounds is something about a month. I would personally, if I were in your position, I would do that, because I would be more comfortable in addressing the bench, in speaking before the bench after a month of practice. So she said, so my moot is in the next 2 days. Should I start practicing from today or tomorrow? So, and I'm not trying to denigrate any kind of intentions which she had, but I'm just trying to highlight a major confusion, a major doubt in the minds of students. They don't know when to start practice. What is the adequate time you need to practice? And more importantly, how do you practice? What is the meaning of this easy word practice? Who do you practice in front of? What do you keep in mind when you want to practice? So I'll touch upon a few basics, and then obviously, as I have been mentioning, if you want to know more about it, you can get our course on oral argumentation, which conclusively deals on all of these aspects. Basically, you need to practice in front of three kinds of people. First is the kind of people who know a lot about the moot proposition. So if, let's say, it's a national level moot court competition, a team from your college which has done that moot is definitely someone who you should be practicing with. That's the first kind. Second kind is the type of people who have an idea about the subject law but are not aware about the moot proposition issue. What this will help, and this can be any of your friends or any teacher also who's done work in that subject area but has not seen that particular moot proposition issue which you are dealing with. What this will help you is, this will help in practicing, in mastering the theoretical, the broader issues at hand. Let's say your moot proposition is on constitutional law, and your specific issue is regarding CAA, right? The Citizenship Amendment Act. Now, the first type of bench, the people who have done a moot on CAA, will obviously ask you specifics on CAA. The second type of bench, which is people who are masters of constitutional law, they will ask you questions on a broader basis on constitutional law, and their questions might range from anything like how can you challenge the validity of a constitutional of any statute from a constitutional law perspective, to something like so broad as from which constitutions of the world have we incorporated Article 14, Article 19, blah blah blah, right? So the second type will help you in the broad aspect. The third type, which is often most ignored, is the type of people which have no clue about the the moot proposition, the subject area. And for this, we always prescribe to practice in front of your juniors. It might seem a little counterintuitive, because why would you want to do practice in front of someone who doesn't know, sorry, who doesn't know about the moot proposition? But what this helps is, this helps in getting questions out of the way which are absolutely redundant, useless, but unfortunately you will never be safe from any such questions from any judge. Now, let me go back to a personal example. My last moot, WBNUJS corporate law moot court competition, I have prepared a lot. Like right now, let's say it's 2016 January, February, the moot is happening. Till January, I have prepared a lot. Like, I've done my research. I've been giving 3 to 4 practice rounds every day. And in February, I think I'm cool. Like, I can do well. I'm the first speaker. I take up matters of jurisdiction. I go before the bench. I say, if it may please the bench, may I please refer to the bench as your lordship. Uh, Bench says, very well, counsel, please proceed. But before that, counsel, can you please tell me what is the color of your suit? I was flabbergasted. I was like, okay, the color of my suit is dark gray, I think. And the bench says, okay. Do you think dark gray is a color which is allowed under the BCI Act? So what I'm just trying to tell you guys is that you can never know what kinds of questions the judge might ask. Another experience, another horrible, but this wasn't so horrible, because a few days before that, I actually read the section which prescribed the dress code of lawyers, and through an article which came on Legally India. Right. So fortunately, I had that in mind, and I spoke, and the judge was impressed. But in my first or second moot, I don't remember exactly, I went up to the bench. I said, if it may please the bench, may I please refer to the bench as your lordship? The judge said, no, you may not refer to us as your lordship. You may refer to us only as Duckworth and Lewis. And trust me, guys, I was taken aback. I was like, what is happening? I don't want to moot ever again. But it's something which you have to deal with, because judges have the power to ask you any kind of question, right? And that is the most daunting part of any moot court competition, getting asked questions which you may not have an answer to, right? And of course, that moot round went horribly. I lost that moot round because my entire flow was based upon your lordships or your ladyship, and I couldn't say Duckworth Lewis. I kept fumbling. So unfortunately, I had not practiced in advance. So my important advice to you is, please practice in advance, and that too much in advance. Mannerisms vis-a-vis non-verbal communication. Okay, so what I mean by this is, a lot of times, a lot of mooters, what they don't realize is that you guys are not just speaking through verbal communication devices, which is basically what I'm speaking right now through my mouth is basically the verbal communication device. But I also have these hand gestures. I also have my head movements, my body movements. My eyebrows are, changing their shape again and again. My face is giving a lot of expressions depending on the mood of my speech. So these are called non-verbal communication. And a lot of times, what I have seen, this is so common that I want to bring it out there, that a lot of mooters don't realize that that when you are asked very difficult questions, sometimes you guys show on your face or through your body expressions that you are not liking the entire environment, and you're not liking the judge asking you these questions. Unfortunately, you are barred from posing any kind of such non-verbal communication which goes against the mannerisms rule of court, which is that you should never throw attitude to the judge. You should never show any kind of disrespect, any kind of, and as all of you know, through a very recent judgment on Prashant Bhushan, the court takes contempt of courts very, very seriously, even though the penalty might be low. But yeah, it's something which the court wants to set a precedent on. And no judge, even in a moot court competition, would like to be shown disrespect of any kind. So please be very aware about your hand gestures, about your facial expression. don't use this phrase. What is this judge asking? Right? So don't ever use that. And of course, I'm telling you all of these things so that you guys improve in your next move. Another thing in terms of mannerisms is that a lot of first time mooters, what they tend to do is they tend to sway their body front and back. This just shows nervousness, this just shows anxiety, and sometimes it's very difficult for us to control this. Sometimes our hands are shaking, sometimes our bodies are shivering, and that is simply because you haven't practiced enough to be a speaker in front of someone who you do not know. So what is the way to do that? What is the way to master anxiety, to master nervousness? To do more practice in front of people you don't know, right? So that part is anyway getting covered in the second point, which I just mentioned, which is not practicing in advance.
So
Answering the bench.
one more thing on the third point, guys, that as far as the non-verbal communication, while the oral arguments are going on, as far as the non-verbal communication is concerned, all the three members have to be mindful of that. Not only the speaker. The speaker is obviously showing the expressions which will he or she is supposed to exhibit the expressions which invite questions from the bench. He should have welcoming expressions, calm and composed expressions. Apart from that, the two members who are sitting on the bench, the researcher or the speaker two, if speaker one is on the podium, they should also exhibit very respectful and composed attitude towards the bench. I have noticed in rounds that whenever the opposing counsel is speaking, for example, if the respondent is speaking, then the speakers for the petitioners or the researcher for the petitioner will start murmuring to let the judge know that he's wrong, he's falling on some point. And this has happened with me also when one of my speaker was murmuring something to me, and he was saying the judge will ask questions, he's wrong on that. And on the contrary, the judge asked my co-speaker to shut up in that particular round because it was very distracting for the bench. So you need to know that there is a sitting posture which you need to know about. You just can't wave your hands like this. You're not supposed to keep a book in your hand. Everything, your hand should be folded, your legs should be folded. Sometimes the members who are sitting on the side, they keep fidgeting their legs, which is again very distracting. And you don't realize while you are doing that but the judge who is sitting in front of you, he has a frame in which only one person is standing and submitting the arguments. And anything else in that particular frame from the vantage point of the judge is disturbing. The judge does not want to focus on anything apart from the speaker. And if you are in any way inviting his attention, whenever you are not on the podium, you are distracting the judge, and it is a folly as far as your non-verbal communications are concerned. So yeah, be mindful for that also.
Yes, very rightly pointed out actually. And so the next thing is basically focusing on how to answer the bench through preemptive questions. Now, when I told you about the second point, not practicing in advance, when you are doing these practice rounds, you might notice that there are a couple of questions which are getting, which are coming up again and again from the bench, from the practicing bench. So what you should do is you should always keep a separate document, a rough document, in which you write down what are the preempted questions, the preemptive questions which will most probably be asked by the bench. And at least to the satisfaction of those questions, you should perfect your answer, right? So the answering the bench, the first part of answering the bench would be taken care of by the preemptive questions list which you have. The second part of answering questions to the bench, which I feel is something which needs to be addressed with all of you. Guys, what do you think is more important? Now, I want you to use the chat box. What do you think is more important? Answering the bench to the judge's satisfaction, or completing your arguments within time? What is more important? Yes, exactly. So as a lot of you have pointed out, satisfying the questions of the judges is more important. And someone has also written both. I can understand where you are coming from, but I can tell you the perspective of a judge. We don't care so much about the time limit, the completion of your arguments as much as we care about satisfying us on the questions which we have asked, because that forms the parameter of our marking. So there are 5 parameters on which we have to mark you guys whenever we judge a move, right? And one of those parameters for 20 marks is the question answer round. So we need to know how well you are doing on that. And if you, what you simply do is, because there's a paucity of time, what you simply do is, okay, I got a question on issue number 2, but I have another issue to complete. I should just answer this question in brief and move on to the next issue. That is a very, very common mistake, a very big misconception. So please don't do that. Always remember that the most important thing is to answer the bench to the judge's satisfaction. And if I may say it out loud, you always need to satisfy the ego of the judge. Please don't take it otherwise. Don't take it as a matter of seniority and inferiority, but it is something which happens in our courts as well. You always need to respect your seniors in terms of a courtroom scenario. A senior who's a judge, you need to satisfy their ego. So if there is a question on which they are adamant on to ask you questions, more and more follow-up questions, you can't simply evade that question and move on to your next argument. That will bring down your marks to a lot of to a great extent. So please don't do that, and remember to answer to the bench to their satisfaction. Okay.
Whenever the oral rounds are going on, and it may so happen that the judges are asking a lot of questions, and the speaker gets very paranoid because he's aware that my time is going on and this guy is just not getting easy with the questions. So please know that the judges are also aware about the time limit. Whenever I judge a moot competition, I know that this speaker is having 20 minutes of his time to submit all his arguments. And I know every time when I'm questioning or grilling the speaker more as compared to any round which goes easy. And whenever I'm aware that I asked a lot of questions from the speaker, then I usually have this idea. It is very reasonable to expect from the judge that since all of my time has been consumed in answering your questions and queries, so in the end, even if you are not able to submit one entire issue, you can request the bench that your lordship, I would like to summarize this in 1 minute or another 2 minutes of this court's time. He will allow that, and he will take into consideration the time which you lost in satisfying the bench. So make sure that your prime responsibility is to, answer all the questions which the judge is asking, because that will in the end make the judge happy who is going to mark you. It is a very human thing to do. It is very, you have to expect it from the judge that if you have satisfied him, he will mark you. So yeah.
So with that, we what we have touched upon today is the 2 parts of mooting. Don't let anybody tell you otherwise. The main 2 parts of mooting, 100 marks are for memorial and 100 marks are for your oral round. So on these 2 aspects, we have tried to apprise you on the intricacies, but of course, due to paucity of time, due to various other hurdles, it's not possible for us to explain everything, and that is the precise reason we have actually created a dedicated course for all professional, for all mooters who want to learn mooting professionally. We've taken, guidance from people who have studied at Harvard, Cambridge, Oxford, and what we've done is we've come out with 2 courses, and those 2 courses are, the first course is the online certificate course on oral argumentation, which the price of it is actually 5,500, but for normal students we are running it at 2290. But to all students who are listening right now, we want to announce a special discount. If you use the coupon code UPES500, and this is for anybody from UPS or outside UPS who's joined the webinar, you will get a flat 500 rupees off, and you will get this at a stealing price of 1790. And trust me, 1790 pay, we give it to nobody, but this is an exclusive price. The second portion of mooting is, of course, the memorial making part. Rachnendra, can you send the links of both the courses on the chat while I explain the courses? So the second course is our online certificate course on memorial making. The memorial making aspect is taken care of. The formatting, drafting, research, all of it is explained beautifully in this course. And this is in fact our flagship course, which is running at 2690 for normal students. And for you, you can get it at 2190. And guys, what we also do is we have a so the form of this is basically as soon as you enroll for this course, you get access to all the material. Everything is on our website. It's a beautifully transformed course through, it's based on Harvard Business School's learning model of active learning, something which we have tried to integrate it in this so that you never get bored. I also took a lot of online courses in my law school. This is, I'm telling you all of you very candidly. I took a lot of online courses in my law school and I hated all of them because they were so boring. They simply couldn't hold my attention. My attention span was roughly 5 minutes, 10 minutes. So the entire time when we were forming these two courses, our only intention was that let the student never be bored. Let's make this fun. So you'll see a lot of infographics, a lot of videos, a lot of quizzes, a lot of fun memes, a lot of fun references to TV shows. All of this is included in the course. And apart from that, apart from the static content, what you will also see is you will also be you will also get access to our live doubt clearing sessions, which happen on every Sunday, and a 24-hour WhatsApp group for live doubt clearing, on which we have various activities like a mock moot, which is optional, and let's say a question of the week or something like that. So I want to tell you that in not just in India, our course is running so well. Just yesterday, someone from University of Birmingham actually signed up for both of the courses because their subject was this year's subject was on mooting. So my humble advice to you is to please sign up for this course. If you actually sign up for both of these courses, if you want to do that, please contact us separately. You can either do that by purchasing the course one at a time, because the coupon code can only be used in relation to one course. So you'll have to purchase both the courses separately, but you'll get it at 38.90 or 39.90 for both of them. So yeah, for anybody who's interested in other any other kind of courses which we have, please, I'm just sending you a form link. Please go ahead and fill this form with your name, university, phone number and email. That is all. What we will do is we will try to make sure that you get in touch with the latest news on the law student circuit. Also, yeah, one more thing which I would like to point out. Rachinendra, can you also give the link for our knowledge center? Also, Rachinendra has sent you 2 links above. Please go ahead and copy these links to your to a notepad or something, and we will also make sure that these links are forwarded to you by your college. What Rachinendra is also going to forward you is, now what I'm seeing in the law school fraternity is that there is no platform. There used to be one major platform where all the law school updates used to be posted, but unfortunately, as soon as I open that platform, all I can see is pop-ups of various universities, of various paid campaigns, and I'm not able to see any kind of event notifications for any law school events. So Rachinendra has just posted the link for our knowledge center. It's a very, very unique page where you will see all event postings, including any kind of blogs, especially meant for law students, right? So guys, yeah, just a second. And please, for anyone who thinks that the session is over, the session is not over. We will be taking a few more, minutes for some more mooting related questions which you might have. Before that, I would also like to tell all of you that these 2 courses have been taken by students of every university in India. We actually, in fact, completed NLS enrollments a few weeks back also. UPS, Jiggles, you name any NLU, you name any private university. All students are taking up these 2 courses so that they can have a proper understanding of what moot court competitions are. And apart from that, you will also see a lot of other organizations coming up with similar courses on mooting. But what I would like to say is that these organizations which are trying to come up with these courses might never actually have people behind them who are actually experienced mooters. So please be wary of that fact while choosing which uh, course you have to take. Please be a rational consumer. Also, these coupon codes are valid only till September 27. The coupon code is again UPES 500. I'm posting it to all of you. Now, I also received an inquiry regarding our Moot mentorship program. What our Moot mentorship program is basically, what we do is we have mentors from Harvard, Oxford, Cambridge who have been mooters at their time, who have won international moots. They mentor teams which require mentoring, and this we had specially set up for private universities, because a lot of times what happens is in NLUs, they what they do is they get help from outside very easily. But for private universities, for students who are first time mooters, it is very difficult for them to reach out to anyone without them having a jack, without them having any kind of rapport with their seniors. So this is to make mentorship available to every student in need. We came up with a mentorship program which gives you 20-hour mentorship sessions with mentors who are the best mentors in India and possibly, outside as well. They will mentor you on any moot which you want to do. Let's say tomorrow, if you are participating in William C. Wiss. So William C. Wiss is a tier 1 moot. Rachinendra, can you also send the mentorship program link here? Okay, so we have divided moots into 3 categories: tier 1, tier 2, tier 3. Any moot which is very new, which is not mentioned in tier 1, tier 2, automatically comes in tier 3. Tier 1 moots are the best of the best moots: Philip C. Jessup, Frankfurt, William C. Wiss. So a 20-hour session for anybody outside your college will cost 30,000. But we are giving you a special 20% exclusive discount on all of these categories, so you can get them at these prices. Rachinendra will just send you the link so that you can also go through the mentorship details, like what happens, how does it exactly take place, because a lot of you might have these questions, right? So now moving forward, just a second, I have another thing for you. Yes. So apart from that, I hope that today's session was at least useful to students who want to participate in moots, in the next coming month or so. For anybody who wants to stay updated about any mooting tip, insight, and event, please join our WhatsApp group. I have sent the link of our WhatsApp group just now. Please go ahead and join this WhatsApp group. You will be updated about everything which you need to know as a law student. Right. So apart from that, please visit our website, which is www.memopundits.com. You can also email us with any query which you had about this session at contact@memopundits.com. We're also on social media, our Instagram handles. And by the way, we post really funny memes. We post really good insights on and tips on mooting. We also have a program called 100 Tips on Mooting, which is a free program for everyone. So for anyone who wants to follow that, please go to our Instagram page and follow us there. So now what we are opening is we are opening the session for any kind of questions which any of the participants who might have. So please go ahead and ask your questions. In the meantime, Ayush, may I please request you to gather all the links which Rachinendra has just sent and probably send it out to the maybe on email to the students or through any kind of communication device which you might have in your college.
Yeah, sure, sir.
And Ayush, I'm also forwarding you the poster. You can also forward that poster. Okay, so yeah. So the first question, Rachinendra, do you mind taking this one?
Any nervousness reduction tips and tricks before and during the oral argumentation you would like to give? Okay, this is something nervousness is not something which can be reduced by doing something or doing anything. You are nervous when you are not prepared, guys. This is the only truth. Your hands are shaking when you're not prepared. You're out of nervousness. You sometimes lose your arguments. It's not because of nervousness. It is because you were not prepared per se with your argument. That's why you get nervous and you lose track and you're not able to submit your pleadings. So the only trick, there is no trick to reduce
In
nervousness.
fact, if I may interject, there is one slight trick which I personally use. It may or may not be helpful for you, and this is scientifically based. So you might want to, base your reliance on this more strongly because it comes directly from science. So there are a few power poses. What do I mean by power poses? Whenever you want to go and speak in front of an audience, there are a few power poses which help release testosterone in your body. And this applies equally for men and women. The hormone which is responsible for confidence, for any kind of aggression, right? Now, what are those power poses? A very simple power pose is if you just open your chest, you open your arms and you move the arms like this. What it simply does is it tells your brain, okay, release testosterone now. And it's simply what it does is, along with testosterone, it also increases the rush of adrenaline. And this is something which I've been following in all of my moots I've done so far. What this does is nervousness ko thoda sa it reduces because adrenaline and testosterone, they have this effect that they make you feel more confident, right? So one trick is of course to just open your chest, open your arms like this before you actually go for the round. Another trick, and by the way, I wouldn't call it a tip or trick. I would call it a proper procedure to reduce tricks, reduce nervousness, which we have covered very immensely in the oral argumentation course. But I'll take the privilege of telling you a bit about those procedures. Another thing to remember to reduce nervousness is when I was asked to speak in front of 30, 40 students in my first year for a presentation for one of my subjects in law school. I remember my hands were shaking like this and I couldn't even speak, even though out of those 30, 40 people, there were 10 people who were my very good friends. Why did that happen? Because I wasn't so adept, I wasn't so confident about my spoken English. And that is something which everybody needs to, understand that all of us come from different backgrounds. You might come from a background where you are where you've spoken English in your houses. Even now, even today, no one in my house actually speaks. No one none of my parents speak in English on a day-to-day basis. So it was very difficult for me to actually be confident in my own spoken English, right? So your next step when you realize this fact should be to improve your English, both verbal and also to some extent your written English, right? And a few, ways to improve your English are obviously we've discussed it in the oral argumentation course, and you can simply, if you just want to focus on that, you can do that through YouTube, through Google. There are n number of ways. One very good way is to install this app called Grammarly. Grammarly is an app which can be installed on your internet browser like Chrome or something. What that simply does is whenever you're typing something on, let's say, an email, that app will tell you where exactly you are going wrong. Not in terms of just spelling mistake, but even in terms of tense errors or any kind of structural errors. So please make sure that you download such apps to make your English better.
And apart from that, one tip which Anant has already given you on how to reduce your nervousness is to conduct as many practice rounds as you can. Because whenever your mind is tackling something for the first time, it tends to get nervous. But if you are accustomed to, present your arguments and expecting questions whenever you are presenting your arguments, then your brain does not get nervous. You know that you have done this for like 20 to 30 times in the past 1 week. So this is not something new which is happening. I know how it goes. But when the practice is not enough or substantial, then you don't know that how it could turn out. Therefore, we request you to prepare in front of every bench, every sort of bench, one which is very much well aware about the law or about the facts, or one bench which is not aware about anything at all. Because one more benefit of preparing in front of that bench is that you get to know that your arguments are not very complex for a person who's not very prepared for. Because guys, it is not always that the judge is prepared holistically on your moot proposition or with the law which is concerned with your issues. It may so happen that the judge has only read across the proposition like 15 minutes before the moot round. So then you need to know that your arguments and the language in which you structure those arguments should be lucid enough to convey what you need to be conveyed. Therefore, it is very important to practice all your arguments in front of someone who is not aware, who does not know, who has no clue about the law or your facts. Because then you know that you are able to present yourself in front of a layman and that person is able to understand what you are trying to convey. So and if at all you're practicing this much that you're focusing, scientifically conducting your practicing rounds in front of every probable bench you can think of, then your brain is prepared. Your brain itself tells you that come what may, I'll tackle it. I've done it all. I've seen it in the past 10 days. I've been grilling on this. I have the practice. I can tackle it. So this is apart from focusing on the tricks, this is actually the holistical method in which you should go about for arresting your nervousness. Guys, you can ask any question with respect to drafting, formatting. Is it necessary to go in sequence of issues?
I would say it's a very commonly asked question, by the way, and something which we also as judges keep in mind. If the speaker is following a special structure, let's say speaker 1 says issue number 1, issue number 3, and the speaker 2 says issue number 2, issue number 4. See, from a very layman's perspective, there is nothing wrong with it. But if I were in your position, I will not do that. And I have personally faced this dilemma a lot of times during my moot court competitions, but I've never gone ahead and, I've never chosen any kind of odd issue structure. So for you as well, what I would suggest you is stick to a structure which does not raise questions, right? So if you are choosing 1 and 3, then the obvious question in the minds of the judge would be, why is this person doing this? Is there an underconfidence issue with respect to the second issue by the first speaker? That may or may not be the case, but the judge will have that question in their minds and might mark you down for that. So if I were in your position, please don't do that. Can you please elaborate more on preparing a transcript? Prachi, so what we would like to tell you is transcript basically has five heads. The first would be how to address the bench. The second would be a very brief synopsis of the facts of the moot proposition. The third would be the actual statement of jurisdiction. If you are not challenging the jurisdiction from the side of the respondent, then probably don't include this in your transcript. Your fourth and main part would be the actual arguments. So the arguments would be not line to line verbatim copied from your memorial, but instead there is a way to do that. It's more explained in oral argumentation course, but I'll give you a very brief example. You never follow IRAC when you form a speech. You always you always first state the conclusion. For example, your lordships, in the present case, my client is arguing that the theft in respect to so and so property has been committed, which is actually the part of conclusion in terms of IRAC, right? So in a transcript, you always start with conclusion, then you prepare the argument followed by the rule and ultimately by another conclusion, right? So it's a slightly technical aspect. You might want to go through the course for getting, and especially to everybody who's attending, I've been informed that a lot of you have already cleared your memo submissions recently and are preparing for your oral submission. So especially for you, if you want to download, get hold of transcript formats, please take up the course, because first of all, It's not a fixed time course. There are no fixed classes. You can do it at your own convenience, which matters a lot, right? So take it up right now. Download whatever you need to download, which is necessary for your upcoming Moot. And once your Moot is over, then go through the course one more time.
One more thing which we also teach in the course is that in your transcript only, transcript is basically a skeleton of all the arguments which need to be submitted. In your transcripts only, what you need to do, you need to frame interjections. For example, you are submitting the first issue, and you know that the judge will definitely, it's very probable that the judge will ask this and this question. In the transcript only, you can form an interjection, and that if I answer this question from the bench, I do not need to submit my argument. I can directly move on to the next issue. This will help you save your time rather than repeating what has already been answered. So you can also put in the probable questions just on the side, and if those questions are answered, you can directly switch on to the next issue. And you can fix the pointers in your transcript that these are the 4 points which I necessarily have to submit in front of the bench. If one of these points is not submitted across the bench, then my case is weak. And in the end, whenever you're closing your argument, you can just have a check that all those 4 points are submitted. Everything which you need to satisfy the bench on should be in your transcript, and it should guide you throughout your preparation, throughout your oral prelims.
So I think with that, we are pretty much sorted on the aspect of fundamentals of mooting.